Hi, I'm Will Shao, real estate agent in the Boston area. Right here, I'm with two real estate attorneys, Jane and Sarah. You want to introduce yourselves?
Sure. Hi, I'm Jane Innamorati, and I have a practice in Innamorati Law Title with attorney Sarah McGinley here in Bedford, Massachusetts.
Great. And today we just want to talk about the real estate transaction process and how real estate attorneys are involved. I like to describe real estate transactions. It's kind of like a relay race. You're working with three professionals: your real estate agent, your lender, and real estate attorneys. So let's talk about real estate attorneys. What's your role like in a real estate transaction?
Sure. Well, we get involved right from the start. When a buyer has an offer that's accepted, or on the flip side, a seller has an offer that they've decided to accept, we get involved right away. There's a purchase and sale contract. If we are representing the seller, we typically draft that contract. If we're representing the buyer, we review it, we add edits, potentially a rider, and we go back and forth with the other counsel to negotiate the terms of the purchase and sale agreement.
Yeah, exactly. So at the time when we get the offer accepted, so in the beginning of the process, you're working with an agent like myself. Let's say you're buying a house. You're finding the house. We get the offer accepted. Then I'll hand you off to real estate attorneys. And then there's a second step called signing the purchase and sales agreement. So that's when you guys get involved and get that done, right?
That's
and then
right.
On the selling side, you guys are probably involved a little earlier, right? Like to get the purchase and sales agreement drafted and sent over to the buying side to get that reviewed.
Yep, exactly. Okay. That's where we're right from the beginning, and when we review that purchase and sale, I think it's worth noting that we're reviewing the terms of it. We're going over all the material items, the risks, the financial liability. So we really walk you through that process.
Okay. So let's talk about the value of real estate attorneys, because in Massachusetts, we use real estate attorneys, but I know in many other states, there are no real estate attorneys. It's title companies or something else, right? Mm-hmm. So tell us a little bit about why real estate attorneys in Massachusetts.
Sure. So as you mentioned, Massachusetts is an attorney state. And what that means is that an attorney must be involved in the process. So they must be involved to assist a buyer to purchase, and the seller must have an attorney to help them sell it. And the reason that the attorney the reason that we are an attorney state and that it requires an attorney to conduct the closing is also because the funds must be dispersed through the attorney's escrow, which in Massachusetts is called an IOLTA account, and that is a regulated account by the Board of Bar Overseers to make sure that everything is fair and not any deception going on.
Yeah, that's to protect the consumer, because you're transferring, hundreds of thousands, millions of dollars at the closing. And it needs to go through, I know with the closing attorney, it goes through their account before it gets dispersed to
Correct.
the right parties, right?
Correct.
Yeah.
So in other parts of the country, it's called settlement, and we call it closing.
Oh, okay.
In Massachusetts.
Okay, great. So one thing, Jane, you and I, we were discussing is this idea of time is of the essence. I see this in real estate contracts here, and you told me that some states don't have time is of the essence. So why don't we talk a little bit about Massachusetts, why we have this and what that means? Sure.
So in Massachusetts, unlike other states, in your example that you had a family member that was purchasing in another state, time is of the essence means that every date in a contract is, we would consider it sacrosanct. You live and die by the date in a contract in Massachusetts. So if a purchase and sale is to be signed 5 days after the offer to purchase, you must sign the purchase and sale on that date or get an extension. The same, the other timeline would be a mortgage commitment. You have to have a mortgage commitment from a lender by the date that's set in the contract, and the closing has to happen on the date that is set in the contract, or you're technically in default.
Yep. Mm-hmm. That makes sense. Yeah, I know for me, as an agent, we always keep track of the dates to make sure if our clients are approaching certain dates, we're either getting an extension or getting some type of resolution to that. And I know with the real estate attorneys I work with, you guys also keep track of those dates for us as well, right? As we're getting close to certain dates.
That's true, and we have in our system, we log in obviously the mortgage commitment date is an important date or a milestone that has to be met for a contract, or that could result in a default on the buyer's end.
Okay, that makes sense.
And Will, just to say, to follow up on what Jane was saying, is that's also where the counseling element comes in, that if you do miss a date, if you do need an extension, what it means for that individual client is part of the job, part of the role of the closing attorney.
Yeah. Okay. So let's talk about some of the fun stuff that you guys could deal with. So I know in transactions, the best transactions are the smoothest transactions, no issues that come up. But I think it might be worthwhile to talk about some of the reasons why working with a real estate attorney like yourselves would be beneficial to somebody, because we do hit some roadblocks or some obstacles. And do you have any stories or anything that you want to share that you ran into that may be helpful for people to think about?
With regards to, as you were mentioning, happy buyers, happy closings, everybody, they pay their money and they get the keys to the house, and that's a happy moment. But sometimes, as we were discussing previously, they don't go all that smoothly, and there can be issues that arise. And the worst scenario is what happens if there is a default. That's not fun on anybody, on any side. If you're a seller or a buyer, and either side can actually default. For example, a seller can default if they leave the property a mess. There's a standard that when you leave a house, it's supposed to be broom clean, meaning no debris, no garbage, and that the house is in the same condition as when you had your home inspection. So, no gaping holes in the walls or the floors. And if during the buyer's final walkthrough, and that's typically within 24 hours of the closing, they find something amiss, then the seller is in a default under the contract. So what typically happens in a situation like that is the seller, either the closing is delayed in terms of dispersing and recording and dispersing, or the seller could give a concession for the mess that they left, and then it's on the buyers to have to remedy it after the closing.
Yeah.
So exactly. So that always leaves bad tastes in everyone's mouth.
Yeah.
The other default on and probably on the buyer side, there's a default situation where the buyer's financing doesn't come through and they have waived their mortgage contingency, meaning that the time frame to get a loan and a commitment from a lender has passed. And now they're expected to show up at the closing with the money, and they're not able to. And under the terms of the contract, that's a serious default, because the contract reads that if the buyer doesn't show up with the money at the closing, they will default their earnest money deposit, which in many instances is about 5%. Is that right?
5% or even more in some cases.
Yes,
Yeah.
and that's a lot of money to be leaving on the table. Of course, we do everything in our power to try to prevent something like that from happening. Oftentimes, it might just be requesting another extension so that we can procure another lender, because nobody really wants to see the seller walk away with the buyer's earnest money deposit.
Yeah, exactly. Yeah. Yeah, I think most transactions we do typically are very smooth, but it's like those instances where we have these little things that happen that are out of our control. It's really helpful to have a real estate attorney on your side. And I know there are many situations where I do a final walkthrough and the house is not cleaned out, and then we have to figure that out. And yeah, it's helpful to have real estate attorneys like you guys to just discuss and figure out solutions as we go through it. So
Yeah, to that point, Will, that I think we all are aware that our interests are generally aligned.
Yeah.
Like the buyer wants to buy, the seller wants to sell, the attorneys, we all want to close this deal, and it's that last minute figuring out how to put the pieces of the puzzle together, working with each other.
Yep.
So it is fun at the end, and even if something comes up, it doesn't mean that your interests aren't aligned. It just means you have to get there in a different way. So it's just working together to put those pieces to make
Exactly.
the transaction happen.
And the great news is working with your agent and real estate attorney, you have people on your side.
Yeah.
When you run into that situation, you're not alone. So having someone on your side that can kind of guide you through different solutions is really helpful. So Okay, so let's talk a little bit about, I know if someone's buying like a condo or a property that's in a homeowners association, there's usually condo docs or HOA documents. I think, those are documents that are reviewed by attorneys as well, right? So can we talk a little bit about what you're looking for when you're reviewing a document like that?
Sure. So what I always hope that a buyer does even before they make an offer, and I'm sure that you assist them with this, is just to look at the rules and regulations first off. Because what if it states that you can't have more than one pet, or that another common, well, pets are the most common, but maybe that you need underground parking, or that you have to, just trying to guess here, but
rental restriction or
thank you,
something.
rental restrictions
Yeah.
and things that you aren't going to, I was going to say, the one, you want to leave your children's toys out by the door.
Oh, okay.
You have to pull them in, or you can't change your own oil in your driveway.
Yeah,
You
yeah.
have to pull it into the garage. If these types of things are you're dead set against, then you shouldn't be purchasing a condominium. The other thing that is important to know is to request the budget and to look at the budget and see if there is a reserve. The reserve is so it is a percentage of all of the condo fees that are collected every year, and the ideal amount is 10% of the collected funds from the condo fees are going into a reserve account, and you want to just look to see if that ratio is about that. Most of these HOAs are professionally managed, and they should be, they're pretty sharp, and they know that. Because what that reserve means is that it is able to cover if they need to replace roofs or balconies or siding, things that are considered common expenses that are expensive. And that's why looking at that in advance before you make your offer is important. As attorneys, we're often asked, though, after before the purchase and sale is signed, to review the condo documents, and that's what I would look at if I was looking at the budget, just to see if there's what the reserves look like. And then the other piece is they also request the minutes from the condo meetings to see what is a common theme. Are they discussing replacing those decks and balconies or roofs? And it looks like that might be coming up, and then you're prepared to be, well, there may be a special assessment coming down the pike after you purchase in order to cover those anticipated repairs.
Yeah, that makes sense. Okay, great. I think title insurance comes up quite often. Can you explain what is title insurance, and do you recommend getting title insurance?
Yes, we always recommend getting title insurance. We do. In a state like Massachusetts, where there's this long, rich history of property transfers, sometimes complicated property transfers, Massachusetts has been here for a long time, and there's been a lot of transfers. And so anytime you purchase a property, you have to keep in mind this is probably the most, if not one of the most important transactions you're going to make in your lifetime. The amount that you pay for title insurance is a one-time payment paid at closing, rolled into the rest of your closing costs. And that provides security and peace of mind that if there was any sort of a dispute, anything were to come up, there was a claim on the title, there was an issue with the title going forward, you would be protected. You would have title insurance, you would have those costs paid for, because those could be substantial if something were to come up. And while typically nothing comes up, we do run a title search, we go back a certain amount of time, things do happen.
Yep.
And I think anyone practicing in this area of law has had an experience where something has come up.
Okay.
And so that one-time fee is worth it.
Yeah. Can we talk a little bit about like an instance of when title insurance is helpful? I can think of one, like immediately. I had a situation where my clients had, so this is on the seller side, and they had a loan and home equity line of credit with a bank that shut down. And that bank, before they shut down, they never closed out the line of credit. So it was like kind of sitting there. And that's where title insurance would be helpful to kind of get that cleared, right? As an example.
Yep, that's one example.
Okay.
I don't know if you want to give another example.
Example that I have is another sales side, and they were friends of ours. They were selling their home after living there 25 years, and they had not purchased an owner's policy when they bought. And the title examination does not only cover the registry of deeds, but it covers the registry of probate as well, because property does transfer through probate. And the examiner found an issue where the heirs needed to sign off on a previous sale. So this must have been 2 sales back. It had been examined when my sellers had bought the property and missed. And so now it was on them, and they didn't have a policy to protect them.
Okay.
And the only good news I can say is because it was in the town of Clinton and nobody moves away from Clinton, that the heirs from 2 sales back were around and they were able to sign off.
Great.
If that had not happened, they would not have been able to sell.
Interesting.
It would have, or they would have needed to open up this probate, and that would have been tremendously expensive. So that was just luck that would happen. But normally, in a typical situation, an owner's policy, they would have just passed it on to the title company, and the title company would have indemnified and then taken on the issue to resolve it.
Okay. So to summarize what you're saying, is it sound like the owners had inherited this property through probate, or
It was 2 owners back, and yes, there was an inheritance.
Okay.
But when my sellers had purchased it, and that same probate record was examined, it was missed.
It was missed, So there's an
and
error in there.
It happens.
So exactly.
And sometimes it's an error, and sometimes it's something that isn't readily available.
Yep.
Someone comes out of the background and said, "No, I was left this property." By an uncle, by a grandparent, by a spouse. And so it protects you not only at the time of the transaction, but in the future when you go to sell your property, if something were to come up, it protects you at that point as well.
Yeah,
exactly.
That makes a lot of sense. Okay, thank you for that. All right, let's talk about, what about homestead exemptions? That's a big one that comes up every time people close, right?
Yeah.
It does. It is a one-time fee, again, another one-time fee, this one a much smaller fee, and it protects a certain amount of equity in your property. So we always give the example that if you are to be in a car accident and you're found at fault, and the person that you hit with your car were to sue you, it protects its $500,000 value in your property that they can't get at. So for this one-time minimal fee, you file it, and it protects this equity in your property for going forward for the length of time you own that property.
Yeah, that makes sense.
Well, and I should just mention, as the tail end of that is there are 3 statutory exceptions where the homestead won't help you. And those are, 2 of them are pretty obvious. If you don't pay the IRS or the Massachusetts Department of Revenue, they are free to go ahead and lien at will against your property. And the last one is if you need to go into a nursing home, then there is no exception for the homestead in that case too.
All right, thank you. Working with a real estate attorney, what's the difference between working with a real estate attorney versus just a general attorney that practices real estate, as their on the side or as their bundle of services?
Sure. I mean, I think it's a specialist. If you have a medical problem and you go to your primary care, they send you to the neurologist, the dermatologist. We are that specialist in that sense. So you can go to a general practitioner, and they oftentimes have a wide range of knowledge, but if something were to come up unique to real estate, you want that specialist who sees it every day, the person who's used to it, the person who knows where to look, the person with that those years of experience behind them when you're negotiating or making a decision. So it's like anything else. There are a lot of really great generalists out there, but if something were to happen specific to real estate, you probably want someone with that trained eye.
And what I'll just add to that is, again, I'd mentioned earlier that in Massachusetts, you have to use an attorney to purchase real estate. And part of that, even though it's a general practitioner, so they're an attorney, and they could do the closing, if they are not, if they don't have an escrow, an IOLTA account. They can't accept and disperse the funds on the purchase. So that by default, they're sort of needing to already defer or find another attorney to assist them with that if they're helping a family friend. And the other piece is, aside from the IOLTA, it's the knowledge that you can't write a title policy. So you have to be qualified and accepted and vetted in order to issue title insurance. So if as a family practitioner that doesn't specialize in that, they're not going to be able to assist their family member or their friend in that process. So by
they're
default,
missing some tools to their.
yes, right, exactly. They're missing some tools, some necessary tools in order to effect the transfer.
That makes sense. Okay, great. And I just want to talk briefly about this because I think some people might think, oh, I'm hiring a real estate attorney or an attorney in general. It's going to cost me a lot of money. You don't have to go into the specifics, but what's the general fee structure when working with someone like you?
Sure. There's an initial fee based on reviewing the purchase and sale agreement. So in any transaction, again, we get involved at the start, and there's a fee involved. That's usually a flat fee. There's some flexibility depending on the complexity of the transaction to look at, review, negotiate, add to, draft that purchase and sale agreement. After that, being part of the transaction, there's a fee that typically goes along with representing you and if you have a lender involved. If there's a lender involved, sometimes but not always the lender sets that fee. So that is something set by the bank. It is the fee that we've agreed to accept in order to represent that lender in the transaction. These fees are small considering the size of the transaction. These are not substantial fees. They are fees that are in Massachusetts in this area. The lender set the fees, and so they're fairly standardized. There are little things that would make it go less or more, if you're being asked to do work outside of the transaction, or if you're end up in a complicated negotiation or with a big issue. But generally, the fees are very moderate. They're fees that are similar across the board, especially when you're representing a purchaser. And again, they're small compared to the overall transaction.
So it's not like an hourly fee where you're billing hourly. It's a flat kind of general flat fee at the closing that you take. Okay.
Right, and all of that money it's collected at the closing, so it's listed as part of the closing costs, and yes, that's how it's paid.
Yeah, that's a great thing about real estate transactions. What some people don't know is none of us get paid unless our clients get exactly what they want. Either they're buying or selling. So that's a positive for a lot of people. So.
Yeah, again, the interests are aligned. Everyone, the buyer wants to buy, the seller wants to sell, and as attorneys and we have your best interest in mind because, like you said, our fees don't typically hit until the transaction is finalized.
Yeah, exactly. Great. I think I've asked all the questions I need to ask. Is there anything else you guys would like to share about being real estate attorneys?
I think our role is bigger than just closing the transaction. We touched on it a little bit before, but as far as counseling and strategic decision making in conjunction with the realtor, but as far as anything that comes up these days, waiving contingencies in a competitive market, what to do if you have waived those contingencies and then something is to not go the way you were hoping. If you decide to waive a contingency but still want to have, for just to take an example, an inspection just for knowledge purposes, or if something changes in your personal life that affects your ability to complete a transaction. That kind of counseling role is something that is part of what we do. That isn't the highlight, it's not the main part of the transaction, but there is a lot of counseling and negotiation which goes behind each transaction. And each one's a little different, and I think that's a big part of our role.
Absolutely. I agree 100%. Even before I make some offers, I might call a real estate attorney and talk to you guys, ask you what are risks, what are the situations I could run into if I were to waive certain contingencies or set it up this way. So, really, we work as a team, and that's really great.
That's true.
Exactly.
Yeah. It is a team process.
All right. Well, thank you for joining me today and sharing a little bit about what your role is in the real estate transaction.
Thanks for having us.
Thanks for inviting us, Will.
Thanks, Will.